Good morning.
In unison, good morning, Your Honor.
Let's see. We have a motion to quash a subpoena. Mr. Levine, is it?
Yes, Your Honor. Did the court have an opportunity to read my motion?
I've read your motion. I don't have a copy of the subpoena.
Could you?
I have to get one.
I faxed it over, but I didn't fax the subpoena, Your Honor. The content of what they want is pretty much everything in the file. And I think the court has previously ruled twice that they were not entitled to that. And I think the court told Mr. Zonin on 2 separate occasions, on the 13th and the 20th, that the court wasn't going to order that. And I just wanted to point out.
You must understand, though, I was telling them that they had to follow the proper legal process. They couldn't just, in open court, ask me to order people to produce records. So you've misconstrued my refusals.
To the extent that that may be, I will accept that, Your Honor. But I think what we have here is a very limited attorney-client waiver. There's been no waiver of the attorney work product privilege. And I think the law is very clear that that privilege is strictly with Mr. Garrigus.
I think you're mistaken there. There was a waiver of the attorney work product privilege. Plus it's very limited in criminal cases anyway. So it's very, very limited, if at all.
Well, 105.46 of the Discovery Code incorporates the attorney work product privilege. I mean, I understand that the waiver executed by Mr. Jackson purported to waive that privilege, but case law is very clear that that privilege rests solely with Mr. Garrigus.
Yes, it's also very clear it's very limited in criminal cases. We've been through this on numerous witnesses here, counsel. We've been schooled well on this issue.
Okay, the point that I would like to make, Your Honor, is that the request is just for everything. And I think that.
I haven't seen the subpoena. That's the deficiency I'm dealing with here.
Could we wait, then, until after you review the subpoena?
Sure.
Thanks.
Okay, and somebody's getting it for us?
Yes, Your Honor.
Yes.
All right, there's another issue here. A couple of issues I want to bring up. One is originally when we allowed the rebuttal tape in, I guess the takeout tape. It was the takeout that. No, it wasn't the outtakes. It was the original Bashir tape. That the district attorney asked that certain things that Mr. Jackson said be admitted for the truth of the matter asserted, and we instructed the jury that certain things would be. That we'd advise them later. Someone brought this to my attention the other day, and I think the district attorney should provide us with the portions of the tape. Not right now. Laughter. With the portions of the tape that show that you intend to argue are admissions, so that perhaps the court should be more specific. At least we should discuss in our preparation of final instructions what areas the jury might conceivably consider are admissions or not admissions, which ones you were thinking about, because it is ultimately a jury question, but there is some preliminary finding, maybe, that I should make.
Yes, I'll do that, Your Honor. I believe I have the notes that were made the day the court ruled as to which ones would be admissible when we went through it. And I'll take the responsibility for that, and share it with with counsel for the defense, and hopefully we can just come up with something we both agree on. It's on the record. I remember we did it in open court, and it was by page and line number, so it shouldn't be that difficult to come by.
And in connection with that, then you had asked for a special instruction along the same lines on the takeout tape.
We did.
The outtakes so we should address. I will give that instruction, but we should address the same issue on that tape.
All right, I'll review that tape. I don't believe there's any in there, but that would be good for us to come to a consensus on.
Yeah, I would want it.
Okay, I'll do that.
And be sure that everyone agreed that was the case.
That would be fine, Your Honor.
I take it you're going to give us an opportunity to argue that motion. I don't think that's actually been heard yet.
What motion is that?
The motion the prosecution made to limit the outtake tape.
Oh, yeah, no. That's why I didn't give. That's what I'm talking about.
Yes.
I want some actual material. What we're talking about. This piece of information, that piece of information, all the information. I want both sides to address that. I'm more concerned. The tape's been shown, you know. What we're talking about is jury instructions on this issue.
Right. Correct.
So I'm just asking you to be prepared to discuss those as we get ready to discuss jury instructions.
Yes, sir.
Judge, can I ask for a point of clarification on that?
Yes.
I understand exactly what the court is saying, but, as I mentioned yesterday, I'm assuming, and I don't want to assume too much, but I'm assuming that some sort of a limiting instruction on the tape in general is going to be given. That it was not admitted for the truth of the matter, except for those portions that may.
That's the issue.
Well, it would affect our rebuttal, because if the court determines that those statements come in for the truth of the matter, then we obviously would be putting on evidence to show some of the statements made by Mr. Jackson during the course of those outtakes were not true. And so that's why we filed it prior to the time that we sit down for instructions. I know I'm not asking the court to carve out those portions of the tape where there may or may not be admissions by the defendant that would come in for the truth of the matter. But generally speaking, there's a great deal of narrative, an interview by the defendant that has nothing to do with what I would believe to be an admission. And so I guess that's what I'm asking the court now, because we need to know that before we rest, because, if some of that stuff comes in for the truth of the matter, we're going to call witnesses to prove otherwise. That's why we filed the motion, Your Honor. And I believe that the understanding on the original Bashir tape was that that was not for the truth of the matter, except for the admissions, and it seemed to me that the same thing should apply to the outtakes.
That is true. That's what the Bashir tape ruling was, and that's the reason for admitting the outtakes. There really was not a truth of the matter admission there. It was to balance the information. It was sort of the rest of the story. I kind of viewed it as a situation where you have a conversation and only part of the conversation is admitted, so you let the other side admit the conversation, or the document. Sometimes part of a document's admitted. It's not clear the total meaning unless the whole conversation, or a whole document. So that's why I admitted the outtakes, was to give the defense, they had been requesting that. They wanted the balance of the total picture and.
But in that case, it would come in for the truth of the matter. The whole conversation comes in for the truth of the matter.
Then the Bashir tape all comes in for the truth of the matter, right?
No.
You just want your side to have the truth of the matter.
No. I understand the irony there, in a sense, but the fact is that the whole Bashir tape has all sorts of other hearsay. The only reason that it was admissible for the truth was that.
I meant as to Mr. Jackson's statements.
As to his statements, yeah. If his statements come in for the truth of the matter.
Whether they're admissions or not. I don't think you do understand the irony. But go ahead.
No, I do. I'm wrestling with the irony at the moment. Ironically, it turns out. Laughter. I understand what the court is saying, and I was just about to concede that, but I don't know, I'd have to think about the Bashir tape. But it seems to me, if Mr. Jackson said things on the Bashir tape, we had limited portions of the tape.
We've already told them they are not to take that tape for the truth of the matter asserted except for certain parts, which we told them we'd advise them about later.
Now, I'm not too worried about what Mr. Jackson said in the Bashir tape. What I'm worried about is, you're not suggesting, Your Honor, that what Mr. Bashir says and other people.
No.
Okay, so that would still not come in for the truth. Then the rest of the conversation, it would seem to me, whether it was on the Bashir tape or the outtakes, the whole conversation would come in for the truth of the matter as to what Mr. Jackson said.
Well, what Mr. Jackson said there was hearsay, and it has to have an exception to the hearsay rule to come in for the truth of the matter asserted, and admissions is one exception.
Well.
Clearly you don't let out of court statements of the defendant in that are not within the normal classifications, and that's what you're suggesting.
Well, generally, under the evidence code, if the entire statement comes in.
That doesn't.
It generally does all come in. I understand, Your Honor.
As to one limited piece of the conversation. You know, if they said, okay, the admission is, I sleep in the bed with young boys, and the other part of the conversation is, but I don't have sex, then, yeah, that comes. That's it. But if, you know, part of the conversation was what he did in town yesterday, no. And that's where we come in. There's a lot of outtake material there that's not material to the parts that are admissions.
Well, and that, I think that's something we need to. I don't know that we can accomplish it right now, because.
Well, the DA says he can't rest until. Literally, he can't rest.
The district attorney is restless.
That's the most accurate thing you've said during this whole trial, Judge.
Okay, well, my first argument is, under the evidence code. I understand what the court just said, but under the evidence code, generally if they let in part of the conversation, the rest of it, ordinary case, the rest of it comes in and it just comes in for the truth.
That's your argument.
Your Honor is saying, well, we need to do something to pare it down. In order to pare it down, it's going to.
We need to do something to give the jury some legal instruction. Some help here, you know. We can talk about it, but they have to decide it.
Alright, now, the tape itself also came in, the outtakes. The Hamid video came in also to show, to rebut the contention that the Bashir tape was such a disaster and there was nothing that could be done except to do illegal things to the Arvizos.
That's right.
And so it came in to show, well, no, we had this in the bank. That was there. That was a strong piece of information or something that could be put out to the public.
Let me ask the district attorney what is your position on the instruction we should give on the outtake tape that Mr. Sanger and I have just been discussing?
Judge, our position is I think outlined in the papers we filed with you. That is, that the outtakes were admitted, as the court has amply pointed out, as simply a further picture of the entire portions of the interview of the Bashir documentary which was originally shown, and that they do not meet any exception to the hearsay rule, and therefore the limiting instruction that you gave the jury early on in this case with regard to the original documentary should be given with regard to the rest of the outtakes. Now, what we haven't done, and the part where we addressed earlier in our conversation is, I can't tell you, as I stand here, whether there are or not any admissions by Mr. Jackson during the course of those outtakes. Frankly, my recollection is that there are not, because I recall that the outtakes ended before the discussion began of his relationship with Gavin and his relationship with other boys and the questions asked by Mr. Bashir about, that dialogue about, well, isn't it, shouldn't an adult man not be sleeping with little boys? So I don't believe that's on the outtakes. So I believe that probably all of the outtakes are probably subject to the limiting instruction, except for one portion. And the one portion I would point out to the court that we put in independent of the outtakes, actually we put in our case, is the defendant's statement about the Jesus juice, as an admission that he did use that term and it corroborates the statement of the kids. But other than that one statement, my recollection, as I stand before the court right now is, I don't believe there's probably any other admissions that would qualify as those that we set out. When I say, we, the court, and counsel for the defendant, and us, in open court and delineated in the original Bashir, which may qualify as admissions. But I'll tell you that my opinion is that the bulk of that tape, the outtakes takes are hearsay and should be subject to the same instruction as the original Bashir documentary. I hope that addresses what the court asked.
It does. Let me ask you a question now. On the tape of Gavin.
Yes, sir.
What's your purpose in introducing that?
Well, we indicated to the court that there were two purposes. And of course one was prior consistent statements. And the other was that there has been an allegation on the part of the defense that this entire case, and the allegations made by Gavin in particular, was scripted by the mother. They presented several witnesses, most particularly Mary Holzer, to try to infer from what happened, or what statements were made in prior cases, or a prior case, that this case is a similar situation. And so we are offering it for two purposes. One is the prior consistent under Evidence Code Section 791, but more importantly, we're offering it for it would be actually a non-hearsay purpose, which would be for the purpose of allowing the jury simply to examine the demeanor and the manner in which the disclosures were originally made by Gavin to the law enforcement agencies. And of course I realize that is a different type of a ruling for the court. And when you ruled that we could show it, I realize that you just made the ruling and didn't say on which basis. And so I do recognize, and I did recognize at the time, that there may be, the way it would come in and whatever instructions you would give the jury may be different, and I do concede that, and so.
If I didn't say it, and I think, now that you mention it, I probably didn't, my intent in allowing that, making that ruling, was to, not for the impeachment statements, but for the purpose of allowing the jury to examine his demeanor and the manner in which he made the disclosures. And it's been my thought to give some instruction along with that, or afterwards when we give instructions, to limit the use of that tape not for the truth of the matter asserted.
Judge, I have no problem with that. For us, the significance of it is simply the way the disclosure occurred, and his manner and the way he behaves and reacts to the officers in what he says. So that's not a problem with us. And I understand the difference. And I kind of anticipated that might be what the court had in mind.
Mr. Sanger?
Yes, sir.
Would you address that point, please? You are doing that issue, aren't you?
Yes. I agree with the court, it should not be let in for prior consistent statements, because that should have been in the case in chief. And that's why we argued that on this thin basis, that it's collateral impeachment of Holzer, scripted, that may or may not apply to this situation. And we argued that it was very, to be able to play this at the end, as we cited the case several times, the Carter case from the Supreme Court, that says you shouldn't be allowed to put dramatic evidence on at the end for a purpose that isn't really, or that goes beyond what the real lawful purpose is, and we still believe that that's the case. So that's the first thing. Secondly, as far as the truth of the matter, I think the court could frame an instruction. The danger, though, would be that no matter what the court says, the jury's going to sit here and listen to Gavin's statement at the end of the case and they're going to hear the words, and there's no way that they're going to be able to disregard what he's saying. And if the court limits it the way the court limits it, there's also the fact that then we can't cross-examine even on some strange remarks that are made by Gavin that may not otherwise be picked up. Because it is our position that this was rehearsed. He had told Devellin this story. Devellin had told Dr. Katz. Devellin had told the police. And then he comes in, and by the end of the statement, he says, I haven't told my sister or my brother about this. If we can't inquire about that, the officer, when they put the tape on, for instance, and say, well, he told you, isn't it a fact that you already interviewed Devellin and she already told you that, and you were aware Dr. Katz interviewed Devellin and she had all the details? I'm just giving that as an example.
And to respond to that example, it seems to me that if the purpose is the spontaneity and demeanor of the child reporting it to the police for the first time, then in fact that cross-examination would be permitted, because, not for the truth of the matter, but because it shows, or it's evidence that a jury could infer shows lack of spontaneity.
Okay.
So it's tricky business, I understand. That's why
We can live with that. That makes sense. I appreciate what the court just said. And that would make sense if we're at least allowed to cross-examine on a couple of those issues like that. I don't know if the court was inviting a further argument it shouldn't come in at all, but I certainly would argue that. I think the court ruled previously, so I don't mean to be arguing with the court.
I did, and I understand that, and all of these issues they're similar legal concepts, and that's why it's good to be discussing all of them at the same time, because invariably one side wants to produce evidence that's very similar to what the other side wants to produce, and they both oppose the evidence.
Right. That's our job.
Well, but I like to make you look at it that way.
No, I understand that. Well, and so in this, if the court was going to let it in, I don't know if the court's considering revisiting that decision.
Well, I would consider, since we're rediscussing it, I would consider anything new that you want to say on that issue, if you felt that you were cut short. I don't want to hear the argument again. I heard the argument, but if there's something you thought of later, or in this conversation we've just had this morning, if there's something else you want to say about that ruling, say it.
What I would add to everything else I said is that, and it's actually become more clear right now, is that, by playing the tape, that could well lengthen the cerebuttal process considerably. By not playing the tape, it would eliminate a good amount of cerebuttal that I think by the time all the dust settles with that rebuttal and the cerebuttal, I don't think the jury is going to be any further ahead in their process of finding out what happened, but...
Well, in that regard, let's talk about your cerebuttal. If it's admitted, if the tape's admitted only for the purpose of the demeanor, spontaneity, that type of issue with Gavin, and not for prior consistent statements or the truth of the matter asserted, you'll be required to address for me each issue, each witness that you intend to call on cerebuttal as to what the significance, relevance of that witness would be.
Well, I understand. I could address that briefly so the court has an idea. I mean, for instance, Gavin would be called and could be cross-examined on circumstances leading up to giving this interview, and whether or not he's spontaneous during the particular interview. And there's some particular issues
I'm not really concerned about Gavin. I could clearly see that. But why would you recall Mrs. Arvizo?
Mrs. Arvizo, because she has. Let me answer my part first, and I think Mr. Mesereau wants to add something there. But we'd call Mrs. Arvizo because that is the reason it's called, the reason it's presented by the prosecution is they're saying this rebuts somehow Holzer's implication that because J.C. Penney's was coached, that this was coached. Well, we would like to call her, now that we've had some further evidence in this case, and confront her with some issues that suggested this was coached. And so,
when you say that, this was coached, you're saying that this interview with the sheriff was coached.
That's correct.
Okay.
And then we have Dr. Katz, because Dr. Katz did the prior interviews where Devellin also told him all the details. And that obviously flies in the face of the idea that this is spontaneous and the police officers are somehow dragging this out of him. And Gavin also told all different details, but generally the same story, with some striking inconsistencies, but generally the same story he told to Dr. Katz. So we would need to go through and show that this is not as spontaneous as it appears. And I think if it's looked at in those eyes, it isn't spontaneous. But if it isn't looked at through those eyes, then, the people are going to say, well, look and see how spontaneous he is. And so we need to do that. We also have Mr. Feldman.
What I really wanted to be sure of was that you weren't going down the street of now you have to impeach him with statements he made post. That's how you see what I'm saying. If they're not admitted for the truth of the matter asserted, we're not admitting them for prior consistent statements, then we're not going to admit them for inconsistent statements.
And if the court does that, if the court's going to allow the tape, and I'm urging the court to reconsider that, because I think at this point it shouldn't be. But if the court were to admit the tape, then I think that would be a good part of the instruction to give the jury, to let them know that we are not going to be attempting to impeach his statement, because it's not offered for the truth. We're not going to be attempting to impeach it at this time. Counsel's not being allowed to, or however the court would phrase it, go into the subsequent statements that were made. Now, we have introduced evidence of some of those previously, so they're in evidence, but I think that would be fair. Otherwise, it will appear that we're just kind of giving up or not challenging what was said. And I don't think that would be fair to the defense. Could I have a second, just to see if Mr. Mesereau wanted?
Judge, may I have a chance to respond just briefly to something?
Yes.
I'll wait for Mr. Mesereau.
I'm sorry. I heard Mr. Sneddon's voice, but I didn't hear what he said because I was talking to Mr. Mesereau.
Well.
Too bad, I missed it?
Well, I don't know. It was pretty important.
All right, let me respond to that, Your Honor. Once again, Mr. Sneddon is wrong.
He said, let me be, he wants to be heard.
On this issue.
On this issue.
I would like to just remind the court, please, on the outtakes, I did have a response. I would like to respond to what Mr. Sneddon said on that. But we are now talking about this other issue, so, as long as you give me an opportunity to do that before we're through.
No, go ahead and respond to the outtakes.
Okay, switching gears here to the outtakes, Mr. Sneddon said the outtakes ended before the discussions about Gavin. Well, that's not correct. That's not even close to being correct. The outtakes are outtakes that were done in June, the end of June of 2002, the first two tapes, and then the third disc is in January of 2003. The third disc, actually, is at the very end. All of the other filming for the entire video, for the entire Bashir video, has been done at that time. In June, some of the videotaping has been done. And the last one, all of it was done. Secondly, not all of the statements of Mr. Jackson were taken by Mr. Bashir's film crew during the same time that Hamid was taping. So in other words, Bashir also taped at other times, obviously in Las Vegas and other places, at the ranch, at other dates undisclosed. We don't know because he's asserting the shield and won't answer. So he has other material that he got, and we don't have outtakes from that. So, first of all, on the outtakes, let me give an example here. If the court is going to limit it, Our first position is the outtakes come in for the truth of the matter because it's part of the overall conversation. And there were cuts from that were played in the actual Bashir, so the whole thing comes in. Second, if the court says it doesn't come in for the truth of the matter entirely, then we would ask that the court look at this liberally. For instance, I was just thinking of an example. There's a point at which Mr. Jackson talks about his former wife, Debbie Rowe. And you recall there's questions about the children and a number of questions that related to the children. If the court is going to start carving things out, I suppose there could be an order that the statement as to the circumstances of the birth of his children would not be offered for the truth of the matter. But the statements that relate to his love for his children and his relationship with his children, particularly in direct response to questions from Mr. Bashir, would be admitted for the truth of the matter, because that goes directly to the issues in the Bashir tape where he talks about his love for children. What Bashir did is, he cleverly and surgically took out what he thought was the most sensational clips from all the footage he had, which included all of this, and he did not include extensive commentary by Mr. Jackson about how he loves children, and Mr. Bashir encouraging him, and Mr. Bashir saying, "Oh, this is wonderful. I've seen your relationship," and he's responding to it. Because that truly does put the statements on the tape in context. So, if we're going to do it surgically, it would have to be somewhere along those lines. Now, the court could probably, if our motion to admit it all for the truth is denied, the court could probably give a general instruction, without going through and saying, the tape up to this part is admissible for the truth of the matter, and then from this counter number to this counter number it isn't. And the court could probably fashion something that covers the subject matter, in other words, saying that the entire tape, give examples, perhaps.
I understand your position.
Okay, very good. Alright, so unless there's a response to what Mr. Sneddon has on the other thing, I'll submit it.
Alright, Mr. Sneddon?
Judge, I'm done on the Bashir thing. I think the court has our position on it. And we'll look at the tape. If there's something on there, there's something on there. If there's not, there's not. I think I made that clear. With regard to the second part, however, I do want to say this, because I think there's been the creation of a misimpression with this court, and that is that the question that you asked about Dr. Katz and the reason that Dr. Katz would be called, and counsel's reference of a fact that Devellin made statements to Dr. Katz about there had been previous disclosures, based upon my recollection of the testimony, is untrue. There had been discussion by Gavin with Devellin with regard to certain incidents, including the showing of the pornography, adult materials, the drinking, the mannequin incident, but there had been no disclosure of the sexual activities between the defendant and Gavin. And I think Dr. Katz was very clear that, in Gavin's conversation with him, there was no disclosure, and when he got to that point he just dropped his head and he wouldn't talk anymore, and that's why Dr. Katz felt he needed to make a mandated report. So I think what I'm saying to the court simply is, before the court opens up a lot of avenues for cross-examination or bringing these witnesses in, I think it's incumbent on the defense to show where there's some testimony in this case that there really was a disclosure of the sexual conduct between the defendant and the victim in this case on a prior occasion, before he disclosed on the video that we're about to play. I believe the state of the evidence in this case is there was absolutely none. This was it. And that this would be collateral to the main issue as to why this tape is being shown. So,
I think, so that you understand, I will require both sides, but in this case specifically the defense, to, before a witness is called, to make an offer of proof on rebuttal as to why they're calling the witness and how it relates to your rebuttal. I'm not opening up this trial again for anybody.
Okay.
So, and at that time you'll have an opportunity to address it. I just wanted, and I appreciate that Mr. Sanger gave me a picture of some of the material he thought he was going to be bringing in, and most of what he said seemed relevant. But I will look at each piece, and I'm going to hold people tight to this, because we're on rebuttal. The case is over. You're on rebuttal.
All right, thank you, Your Honor.
On your subpoena, come forward.
Yes, my more boring issue, Your Honor. Just to keep it very brief.
I don't think your issue is boring, counsel.
Thank you, Your Honor. Compared to the others, with the benefit of hindsight, it seems that Mr. Garrigus testified pretty much that he ordered surveillance in this case and the reasons why he did that. And I think that's the extent of what both sides were getting at during the cross. We have here an attempt to basically try to get billing statements, everything related to his representation. A lot of that, the court can see, is irrelevant to what has occurred. It would be beyond the scope of both cross and direct. And I think what he stated in his testimony is that he didn't take any notes. He didn't have any tapes. Whatever emails there were, the court, they have been provided by the defense to the prosecution. And I think that Brad Miller, who did the surveillance and would be the relevant witness as to what occurred during the surveillance, I think he was raided, and I think that there was a search warrant served on his offices. I don't really think that the records, his billing records and what are other extraneous items that may be in the file, are really relevant at this point. I think both sides, Mr. Zonin did a very effective cross-examination that lasted almost 5 hours. And I think that there's really nothing left to do in this particular area. So, it appears that the request, as it's framed in their subpoena, is just overbroad, putting aside any privileges or any other issues. And I think that it would be better if there was something specific that we can respond to. I mean, you have to understand, the file with Mr. Jackson, the brunt of it is just box. I don't know how big it is. I haven't seen it, but most of it is after he was arrested. So there would be a lot of.
That seems to be one of the problems with the subpoena, now that I see it, is that there's not a limitation to the time period that the waiver purports to. You know, it appears to be overly broad from the standpoint that they subpoena everything, which, you know, clearly they are not entitled to subpoena records beyond the time waiver.
Even if we limit it to records within the time waiver, I mean, let's say they add that sentence and it's in there, which I think that was their intent. Again, it's just a situation here where, at this very late stage of the trial where everybody has rested, and we're getting back into what seems to be very insignificant information. Mr. Garrigas's testimony was very collateral to, it's just ancillary, a very small part, and he just basically ordered surveillance. And it seems that
it's a little more complicated than that.
I understand. I read.
You didn't see the trial, so I'll accept.
I did see parts of it. It was very compelling, Your Honor. I was here last week. But I think that it would be better if we can just have.
One of the things I'm addressing is there was some testimony just yesterday about the number of phone calls between Mr. Garrigas and other people involved during this period, which flies in the face of your assertion that he just ordered surveillance. You know, that's not true. He was very involved in a lot of that, you know, what was going on, and that. So I just have to tell you, your assertion doesn't stand up. But
I'm not suggesting that he didn't talk to people. The fact that a phone call was made, again, just seems, again, what the defense called him for was for that purpose. That other items came up, I understand. I'm just trying to.
You have to realize that, until the defense called him, he claimed the privilege, and the district attorney couldn't call him. They couldn't subpoena his records. In fact, I had a special master spend months going through the emails, the computer hard drives that were seized, and segregating out the privileged material, only to have him come into court and have the privilege waived. So what may appear to you to be a late subpoena isn't late at all, considering when Mr. Garrigas and Mr. Jackson waived the privilege.
All right, we didn't like that argument. We didn't like the attorney-client and not the attorney-work product. I understand that.
I'll just make this easy for you. I'll make it easy for me. Excuse me, not for you.
Thank you, Your Honor.
I'm going to allow the subpoena, but I'm going to limit it to materials that are within the scope of the waiver.
Okay, is there a time frame as far as, I know that the boxes are in storage somewhere and they have to be pulled out?
Well, Mr. Garrigas actually said he didn't think there was much material.
I agree.
So it can't be very burdensome. He didn't think there was hardly anything.
Well, that would be me, though. I would have to go through the boxes, Your Honor, so.
All right, we're back in session Tuesday. That's when I want it here.
Thank you, Your Honor.
Your Honor, would it be possible to get it earlier than that? Given the reality of our case, we're going to be done Tuesday.
They can't hear you back there.
One of these days I'll remember this. We believe that we will likely be resting on Tuesday. If we don't get the materials until that time, and frankly, if we have to wait till Tuesday, we would probably need Mr. Garrigas's presence here. If we could have it before Tuesday, we might be able to resolve a stipulation where he wouldn't actually have to come, that we could perhaps stipulate to the admissibility of some materials. But we would need the materials in advance of that date. Otherwise, I'm afraid Mr. Garrigus would have to be here on Tuesday, as he would be the only one to lay the foundation for the introduction of those documents, assuming there's some relevant documents among the file.
I really have nothing to do this weekend, it being Memorial Day weekend. I'm happy to accommodate this request to go through it. I don't really think there is much, because I think his testimony was he didn't take notes, he didn't have tapes. And I know that.
That's pretty much what he testified to.
He also turned over a lot of stuff to the defense, which I would assume they have possession of and they would be obligated to turn over to the prosecution, given the fact that they waived the privilege that they had.
They have different obligations. You're only required to turn over what you have, not what's been forwarded to other people. So in order to help bring this case to an end, and to ruin your weekend, I'll order that you present it on Monday to the district attorneys.
It's a lovely drive here from Los Angeles, Your Honor.
He'll only have to go to Santa Barbara.
Okay.
You should make an agreement how you're going to get together.
I'll do that. Thank you, Your Honor.
Thank you, Your Honor.
Thank you. What I want to do is. You want to say something?
I do. I just missed the last part there. These are documents that are subpoenaed to the court, not to the district attorney's office. I don't mind them being delivered to the district attorney's office if we have an agreement that they will immediately provide us with a copy.
So ordered.
Thank you.
But I don't think they were listening this time either.
I was listening.
Oh, you were. Okay. Oh, it was you that wasn't listening last time. I get confused about who's not listening. Don't bring the jury in. I want to just take a couple minutes and look at some material here before you bring the jury in. To the jury, I know what you're thinking.
Oh.
You're probably thinking, well, if you don't want us to come in until 9:15, then why do you have us here at 8:30? Right? This is just a little bit more complicated. We're in the rebuttal stage, and the legal issues become more complicated, and I'm just trying to take care of them as quickly as they come up and then get you in here. Just think of it this way. You only have 15 more minutes till the break. Counsel, you may proceed.
Thank you, Your Honor. First of all, I'd like to begin by having another photograph marked as 909 for identification purposes. I've shown it to counsel and I'd like to approach the witness, with the court's permission.
You may.
Detective Bonner, yesterday, we were talking during your testimony about the location of the two areas where the sensors were located in the downstairs area of Mr. Jackson's bedroom suite, okay? And I've handed you the exhibit marked as People's 909. Do you recognize that photograph?
Yes, I do.
And have you seen that area before?
Yes, I have.
And is that photograph an accurate depiction of what it purports to represent?
Yes, it is.
Your Honor, I'd move that 909 be admitted into evidence.
No objection.
It's admitted.
Your Honor, could we have the input for the Elmo, please? We put on the board the photograph. Excuse me. There we go. The photograph marked as 909, which is now in evidence. And do you recognize that photograph?
Yes, I do.
Okay. And in that photograph, do you see the areas where what do you call them? The enunciators are located?
Yes.
And I guess I should give you the red, that's the laser. Would you, first of all, point out the locations of what you call the enunciators?
The two enunciators, or alarm speakers, were located, the first one, underneath this bookcase cabinet, right down here.
You're indicating in the lower left-hand corner of the exhibit 909?
Correct. Underneath it.
All right.
The second enunciator was located underneath this chair, or throne.
Okay. Now, I'm going to show you another photograph marked as 54, which is in evidence. Do you recognize that photograph?
Yes, I do.
And that's the same chair. The chair that's depicted in that photograph is the same chair depicted in photograph 909. Is that correct?
That's correct.
And was that the location of the chair the time that you were out at the house in November of 2003?
Yes.
And was that the location of the sensor, or the enunciator that you mentioned on that occasion?
Yes.
And the same thing in December of 2004?
Yes.
So, and this is. Which door is this?
This is the doorway that leads from the hallway into the private area of Michael Jackson's room, or the living space downstairs.
Alright, now, the next photograph is People's 69, which is in evidence. You recognize that photograph?
Yes, I do.
And is the cabinet depicted in that photograph the same cabinet that you referenced earlier in your testimony?
Yes, it is.
And the room just to the left of that cabinet is what room? What is that?
That's the bathroom with the jacuzzi tub.
Okay. And again, was this the same location? Was this cabinet and the annunciator in the same location as depicted in this photograph on the 18th of November, 2003?
Yes. However, due to the angle that the film, or the photograph is taken at, you cannot see it in this photograph.
But you did see it personally?
Yes.
And in December when you went out there in 2004, was that cabinet still in the same location?
Yes, it was.
And the annunciator was still in the same location?
Yes, it was.
We can have the lights, Your Honor. Now, Your Honor, I have an exhibit which has been marked as 908 for identification purposes, and I've indicated to counsel what portion of the exhibit that we want to play, and we have it preset to that portion. And what I've told counsel that we would do, if this is okay with the court, is that we will take the portion that's played in court out of this exhibit and provide that, simply that portion, for the court in case the jury wants to look at it later. In other words, we'll substitute, not, we won't substitute. We will provide a 908A, which will have just the portion that's shown to the jury.
That's good.
Because there's other matters on here, and we didn't have time to do the editing on it. And I think that's acceptable to the court and I think that's acceptable to counsel.
Yes, it is.
All right, that's good. I'd like you to do that.
We will do that, Your Honor. So this is Exhibit 908, and we're going to. Let me ask a few foundation questions and then we'll show it. Detective Bonner, you had occasion to review a DVD disc of some portions of the search warrant that was executed in December of 2004, correct?
That's correct.
And you were present when those portions of the video that the jury is about to see were filmed, is that correct?
Yes, I was.
In fact, your voice can be heard on the video?
Correct.
And with regard to the portions that we are about to see, Your Honor, I have another exhibit that I'd like to have marked as People's 907 for identification purposes. I've shown it to counsel, and it's a diagram. And I'd like to show it to the witness and authenticate it before we show the video.
You may. How long is the video now?
Very short. It's
About 40 seconds, 45 seconds.
40 seconds. What's the number on that? 907?
Absolutely.
Your Honor, can I ask the questions here? I'll talk real loud, if that's all right. I'll go back and forth. I could use the exercise. 907, do you recognize that?
Yes, I do.
Did you prepare that?
Yes, I did.
And does that purport to be to scale or just an illustration of the various locations of the rooms of the defendant's master bedroom?
This is not in any way to scale. It's just a quick drawing just to show relative location.
With the court's permission, I move that be admitted for illustrative purposes of the witness's testimony that he's about to give.
No objection.
It's admitted.
All right, I think we'll play the video and then we'll go back to this exhibit.
All right, whereupon, a portion of a DVD, People's Exhibit 908, to be later marked as 908A, was played for the court and jury.
All right, for the record, that portion of the video that was shown was 1920 to 1955. Now, we could have the lights again, Your Honor. Mr. Sergeant Bonner, where was the cameraman located at the time that those chimes were going off?
He was standing directly in front of or on top of the area where the annunciator was located underneath the bookcase, cabinet.
All right, let's put this Exhibit 907 up on the board, if we can. Okay, this is Exhibit 907, correct?
That's correct.
All right, now, on the particular exhibit, you have the laser there, you have an annunciator one, with a little square, is that correct?
Correct.
Where is that located in relationship to the room?
Annunciator 1 is located right here. This was where the bookcase was. And the annunciator was underneath the bookcase.
All right, And could you illustrate to the ladies and gentlemen of the jury the approximate location of the cameraman at the time that they heard the chimes going off in the exhibit 908?
Our camera person was standing right above that bookcase pointing down, at one point in time directly, the camera pointing directly at where that annunciator was at.
You're indicating just to the top left of the small square, correct?
Correct.
Or rectangle?
Through the video, he moves, he starts out approximately right here, and I believe he ends right about here.
Okay. And then with regard to the Annunciator 2, what does that relate to in your previous testimony?
Annunciator 2 was the non-working annunciator that was underneath that red and gold chair.
Now, using this diagram as a further illustration, you were shown a photograph yesterday that showed one of the sensors up in the ceiling prior to, close to the entrance of Mr. Jackson's bedroom door, correct?
Correct.
And would you show us the location of that on the diagram?
It is right here, and I have called it curtain sensor 1.
Now, in November and December, November of 2003, let's take them one at a time, was that curtain sensor working?
Yes.
And in December of 2004, was that curtain sensor working?
Yes.
All object. Asked and answered, Your Honor.
Overruled. Next question.
With regard to the exhibit, 907, you have a second curtain sensor located on that exhibit, correct?
Correct.
And why don't you show the jury where that's located?
That's located prior to the doorway leading into the foyer. Right there.
And was that sensor active on November 18, 2003?
It did not activate any alarms.
And with regard to December of 2004, was it working?
Again, it did not activate any alarms.
You weren't out at the ranch in February and March of 2003, correct?
Correct.
Alright, I'm just going to ask you one other thing and then we'll be done. I've handed you the exhibit that, it's 907, correct?
Correct.
And would you please put on exhibit 907, with the red pen I've given you, the approximate location of the Sheriff's Department cameraman at the point where the video was played to the jury. So with regard to exhibit 907, you've placed a little red figure on that, is that correct?
2 circles with a line between the two, approximating the positions that you observe him to be in.
So he moved during the course of the filming, is that right?
Correct.
But in that area. That was the area during the entire time that the chimes were ringing?
Correct.
Okay. You've had occasion to view the defense video of the 3 scenes where the chimes were filmed?
Correct.
Okay. And with regard to the time that those were filmed, could you determine, from your experience of being out there twice, whether both of the annunciators were working on that day?
I believe both annunciators were working when the defense did their video.
I'm going to move to strike that. I didn't understand the question. I move to strike the answer for the purpose of objecting. That would call for speculation. There's no foundation. He wasn't there.
I'm about to ask him that question.
All right, I'll sustain the objection and strike the answer so you can.
Have you reviewed that video?
Correct.
And from reviewing that video, are you able to determine whether or not both of those annunciators were working at the time that the defense conducted their experiment?
Yes.
Objection. He answered. He just answered, yes or no, so that's fine.
And are you able to reach that opinion based upon your prior experiments and familiarity with how this system works?
Yes.
When you were actually out there?
Yes.
I would ask you how. What is the basis of your opinion that both annunciators were working the day that the defense filmed their exhibit concerning the chimes in the Jackson suite?
Objection. Your Honor. Assumes facts not in evidence. There's no evidence as to his opinion, only that he had one. And I object to his opinion, to any opinion, as not being based on an adequate foundation.
Overruled. I'll allow the answer.
There are 2 different annunciators located in 2 different locations. There are 2 different curtain sensors located in 2 different locations. We know, based upon our being there in December of 04 and on November 18 of 03, that curtain sensor 1 activated annunciator 1, which is located furthest from the stairwell, and that would presumably have a lower volume than if annunciator 2 was activated, based upon the filming with the individual in the upstairs. When you listen.
Excuse me. First of all, it's a narrative. And second of all, I move to strike the last part as being an opinion without a foundation.
I am going to sustain the objection and strike the opinion.
Are you able to tell, from a review, based upon your familiarity with the system and your having been out there, are you able to determine, yes, or no, from a review of those films, that both enunciators were working that day?
Yes.
And are you able to determine that based upon your review of the sounds, the differing sounds that the chimes make at certain portions during those scenes?
Yes.
Were you also able to determine, when you were out there before, that the enunciators have 3 volume settings on them?
No.
Multiple volume settings?
Objection. Leading. Asked and answered.
Overruled.
No.
Did you determine that at some other point in time?
Yes.
All right. I have no further questions on this subject, Your Honor. But I believe at this point I would have this witness. I'll ask one question, and then I think we have a stipulation to offer to the court. And we can have the lights.
First of all, I want to object to the last question and move to strike the last answer for the purpose of objecting to the question on the grounds there's no foundation.
Overruled.
During the course of your role in this investigation, was it your responsibility to review the items that had been obtained through the course of the search warrant process?
Yes.
And was one of the assignments that you had to determine the items that were seized from the office of Investigator Brad Miller?
Yes.
And during the course of that review, did you determine whether or not there was a tape that was recovered from Mr. Miller's office that dealt with an interview between Janet Arvizo and the Department of Child and Family Services in Los Angeles on February 20, 2003?
There was not.
All right. I believe the stipulation, Your Honor, is that.
Tom? Oh.
Do you want to read it? That's fine, thank you. I'll read the stipulation, Your Honor, into the record, if that's appropriate for the court.
You may.
Both sides are willing to stipulate to the following: that prior to the trial, both the prosecution and the defense exchanged documents and other evidence with each other, and on December 6, 2004, the defense provided to the prosecution a copy of the DCFS interview of February 20, 2003.
Is that your agreement, Mr. Mesereau?
The stipulation reads, we provided the prosecution with our copy of that interview, I believe.
All right.
That's fine.
Is that your agreement?
That's our agreement.
Is that your agreement?
So stipulated, Your Honor, yes.
All approve that stipulation. To the jury, when the parties stipulate to a fact, the jury is bound by that stipulation.
Your Honor, I think probably to tie things together for the jury and the court, we should indicate that the stipulation we entered into is directly related to the exhibit that has been played for the jury here in the courtroom. And I don't have, I'm sorry. I apologize for not having the exact exhibit number, but I will find that and provide that to the court later, if you want.
I'm not sure what that even refers to, Your Honor.
I'm referring to the tape that was played of that conversation that the jury heard, which is the February 20th DCFS interview.
I'm not stipulating to that. I'm just, if he wants to argue that, he can. The stipulation is the stipulation.
To the jury, all right. So you're not bound by what they don't stipulate to. All right, let's take our break.